legal context. So there's two main parts to this: your experience and your child's experience. The reality is, with family court, is when there's children involved, they're only really interested in your child's experience. If you don't have children, but you are going through divorce, the key pieces of legislation are the Serious Crime Act of 2015, which is when coercive control first became a criminal offence, Domestic Abuse Bill 2021, which includes more about coercive control, pro-separation abuse and domestic abuse, and the Domestic Violence Crime and Victims Act of 2014. Domestic abuse allegations will usually be investigated under Practice Directive 12J and often include a fact-finding hearing where each allegation can be investigated. Not every case will need a fact-finding hearing, but where there's a lot of allegations and those allegations are disputed, then a fact-finding hearing can be really helpful. So we're going to provide some definitions, and I recommend that you use those definitions to build your case. And we are going to focus from here on in on the child's experience. And this is the most important part of your case because they are primarily concerned with the welfare of the child. Their job is to reduce the risk of harm to children following divorce and separation when making child arrangement orders. So the first thing to have a look at is the welfare checklist. And I strongly recommend that you use this as a framework for your case. Once you've organised the evidence in Evidence Tracker, you can begin to pull out the evidence under each section of the checklist. In terms of risk, point 5 is the most important. So I've provided that in a separate document that you can have a look through. But the most important one is any harm which has suffered or is at risk of suffering. So the court will examine harm that the child has suffered and that you can evidence they have suffered. Also, harm that the child is at risk of suffering in the future. To clarify, harm is defined as ill treatment or the impairment of health or development. And the court will weigh up the potential risk to the child and issue an order which is reflective of that. The order could feasibly contain protective measures which are aimed at safeguarding the child, and this particular criterion will require the court to examine allegations of domestic abuse. And we're going to look at that more in another lesson. So the second area is that children are often coercively controlled and psychologically abused in these sorts of relationships. They're conditioned to reject one parent in favour of the other, and this is known as parental alienation, which makes it adult focused. But the child is being harmed. That's where the terminology of parental alienation is questionable, because the child is the one being harmed, and that is where your focus should be, not about your experience. Although that is valid in family court, you need to focus it on the child. So at the time of this recording, alienation isn't specifically mentioned in the domestic abuse bill, but it does have a place in the guidance, and hopefully that will remain in there. The bottom line is that it is recognised in law. There's lots of case law that it's included, and again, I've provided you with some of that you might want to use and look at. There is an argument that it should be covered by coercive control, but coercive control is adult to adult, and therefore it takes out the child element. So I've provided some of the guidance and the wording that's taken from the CPS for you to look at and understand. I've also provided you with a checklist, really, of the behaviours that the courts, that the legislation includes as being coercive control, emotional abuse, the child as a witness to domestic abuse as well. And these are all really important for you when you're building your case. So go through your case, tick the ones that apply to you, then start adding your evidence into each one of those categories, and there will be crossover on them, and use Evidence Tracker to do that, because Evidence Tracker has those categories. So you are then using the legislative framework to demonstrate your child's experience, which is much more powerful.